And at this point, we have to start looking at the ever-changing, ever-multiplying socio-political challenges of Nigeria and what must be done to prevent the total, well, seemingly total erosion of the unifying fabric necessary for meaningful nation building. And citizen action step into the void being created by the seeming unresponsiveness of government. And if yes, to what extent? Can ordinary citizens take steps to effect an amendment of the country's constitution? And shouldn't government be doing more at this point to reach out for wider consultation with critical stakeholders? Joining us now for this chat is Dr. Daniel Bwala, lawyer and member of Lincoln's Inn, London. Welcome to the program. Good morning.
Thank you. Talk to Dr. Abati, Tudun, and most honorable.
Good morning,
very
Doctor.
Quickly, Daniel, some groups, some of the members of such groups are very prominent Nigerians. They've been talking about coming up with their own constitution. The usual phrase is a people's constitution that can replace, if possible, the 1999 constitution that so many people have complained about. Can ordinary citizens, whether they belong to a group or to whatever platform, on their own, come up with a constitution that they can give to Parliament or give to Nigerians? Could you take us through, the legitimacy of the initiative as has been expressed, not by one group, not by two groups?
Well, thank you for having me. The only legally and constitutionally recognized platform for constitutional amendment is contained in Section 4 of the Constitution of Nigeria, and it says the legislative powers of the Federation lies with the National Assembly. Any other body, organization, individual, whatever they come up with at best is an opinion. Thankfully, we are at the moment of constitutional review process, and I can tell you that very shortly, the Senate Committee for Constitutional Review are going to commence public hearing. So this group can bring the document in whatever way, form, or shape that they draft and bring it to the public hearing. First of all, they are even out of time, having not sent it when there was a request for memoranda. And as a consultant in the constitutional amendment process, just recently we had a retreat where we analyzed the over 260-something memoranda submitted by Nigeria that cut across wide range of issues and subjects. And these have been analyzed and submitted to the Senate Committee for their consideration. But I think that if this body or group come up with what they call constitutional amendment, if they approach the National Assembly, most likely they will be granted a leave out of time to submit that as a memoranda, so that during the process of the public hearing, they can make a case for the constitutional review that they are doing. Anything other than that, what they are doing is just an exercise in futility, or rather, just like having a conference or a good time among themselves. But the only constitutional recognized means of lawmaking lies with the National Assembly. And this typifies, let me be honest with you, the gradually decline in our polity of respect to the rule of law and democratic process. What they are doing, if they bring it as an opinion, then it is accepted and acceptable. But if they push it as a position that must be adopted by the National Assembly, then this is what we call legislative banditry. Legislative boundary. Just in the same way, we have individuals around the country who will not want to participate in calling their lawmakers to book or to air their mind, but rather resort to arms, believing that when they hold arms and begin to terrorize the state, they will command the attention of the Federation for dialogue for the purposes of meeting their objective. So we must all come together around this constitution and the constitutional process of constitutional amendment. There is nothing that cannot be discussed, that cannot be amended in our constitution. The constitution is clear regarding procedure for the amendment of the constitution. But this group, which constituency are they represented? How did they assemble themselves? Were they represented? Are they representing the constituency? Were they sent by the constituency? Because that, again, if you have to hear them, it is an ambush because they cannot prove that they were elected to come and discuss the constitutional process. And then whatever they are discussing at the moment is not the aspirations of the Nigerian people because they do not have evidence to suggest that they have gone around the country and have sampled the opinion of Nigerians. So it is a group of scholars and distinguished scholars, I have the greatest respect for them, but who are trying to perform constitutional amendment by means of legislative banditry.
Spoken like a true lawyer, you're a stickler for procedure, and the form has to be followed. But can you share what you've just mentioned, that your committee, your group discussed over 200 possible amendments and submitted those to the Senate committee? Can you share some of those? And does any of these have anything to do with restructuring, which you will recall is a campaign promise? It's a promise that was to be delivered to Nigerians by the ruling party.
Right. So first of all, the Ninth Assembly, they are open to constitutional amendment and have not indicated any no-go area in the conversation. I am well aware because everything started from the office of the DSP and we started nursing this idea or midwifing this idea. El-Rufai report, El-Rufai APC-led report on restructuring is part of the document for consideration in this constitutional review process. The 2014 COFAP conference document is also part of the consideration of the Ninth Assembly in the constitutional process. We have also received over 268 or so memoranda that touch on all areas, including restructuring, devolution of power, resource control, state creation, legislative reform, judiciary reform, and in all aspects of our polity. And I'm sure that when public hearing commences, nobody will be shut out from airing their view and making a case for the Constitution amendment. But of course, you know, and Nigerians will know that the procedure for when what you conceive as an idea or what you draft as a draft bill to when it becomes an alteration in the law based on the provision of the Constitution will require almost the endorsement or participation of the entire facet of our national representation. So this is what the National Assembly, Ninth Assembly is looking into. There is no topic that is off the table. Everything is subject of discussion.
But the shocking part is a lot of people don't trust the National Assembly on this. And that has always been the refrain of people that kick back at this. And they say, oh, this process is shrouded in a lot of, I don't even know what to call it now, maybe constitutional banditry itself. Let me use your word and your coinage. Because when you go through all the reports you stated before, you've talked about the CONFAB reports and the like and things like that. Those reports have been on ground. The successive National Assembly have not done anything about it. And people are even putting it one step further to say, this is just a rubber stamp National Assembly. Nothing different will be done.
So I will tell you that this Ninth Assembly presents the biggest opportunity for the constitutional reform. Now, in the 8th Assembly, you remember, if memory serves us well, that Saraki encumbered himself with fighting executive rather than pushing for a legislative reform. And for a constitutional alteration process to succeed, all the arms of government must be in tandem. Now, the good news here is that the president, as a person, has never indicated his lack of interest or his lack of support for the Constitution review process. But there is what is called lobby in constitutional reform. I'll give you an example. If you come from the Niger Delta, the oil-producing state, and you have a bill for, let's say, derivation, to increase the derivation amount, your representative in the National Assembly they are supposed to take it a step further and begin to engage with other legislators from the other parts of the country and begin to trade. What are you looking at? Maybe the North is looking at certain alteration of the Constitution. And then you begin to say, I will support this bid, support my bid. It's lobby. It's recognized by law. But most of the times, we tend to think that legislative reform is going to happen by you making a case without more, without engaging with others, without discussing with others. And that's where the problem we've had it over time. It is also not true to say that the constitutional alteration process that were proposed in the 8th Assembly, all of them were thrown. I am well aware that the president has signed a number of them into law, but those ones that caught controversy, the president did not sign. I will give you an example. In all of the documents for alteration in the 8th Assembly, some were shut down at the National Assembly stage, at plenary, some at the committee stage. Some succeeded, but the State House of Assembly refused to take them. Some State House of Assembly considered to the idea, but the final constitutional review process failed. All of these processes involves lobbying, involves wider engagement, and cross-border conversation. So as it is happening, you saw a number of governors from the north going to the southwest to have a discussion with the governors in the southwest. You see movement here. That kind of synergy will help in first raising areas that are of concern to you, so that all of the respective governors from every part of the Nigerian nation will weigh it on their lawmakers that in the National Assembly on this subject, make sure it succeeds and don't oppose it, because we are at idiom and in tandem with this part of the country. What is lacking in Nigeria from day one until date, it is dialogue. You see banditry because there has not been dialogue. You see oil bunkering because there has not been dialogue. Even among the members of the press, there is no conversation. So what if we embrace that? I can tell you this is the greatest opportunity we have to amend the Constitution in such a way and manner that it will unify the country as a whole. There are individuals who do not even trust the Constitution at all. And their position is that the preamble of the Constitution says, "We the people," and that they said it was not we the people that brought it to bear, but the military. I have given counter-argument to that. The military did not draft the Constitution in military cantonment. They appointed professors and legal minds and public interest people from different parts of the country. So I think that if you come from any section of the country and you have an agenda for a reform, this is the time to begin to put pressure on your lawmakers, never to sleep but to raise the issue until that is considered.
Well, Daniel Bwala, we'll take a short break now. When we return, the conversation will continue. Just stay with us. It's still the morning show. Still the morning show here on the Arise News channel, and our guest is still Daniel Bwala, lawyer and member of Lincoln's Inn, London. Very quickly, let's move beyond the constitutional matters and the effort of the National Consultative Forum and others to come up with a draft constitution for the people of Nigeria. If you look at the papers today, one major story, the president declaring what is called a no-fly zone across Zamfara for security reasons. Now, what's a no-fly zone? What's the legal status of it? And then secondly, the declaration also that the security agencies should shoot on sight anybody that is found anywhere in Zamfara state carrying an AK-47 or AK-49 or any kind of automatic weapon. What do you think of those two measures as an attempt to ensure security, specifically in Zamfara state, we are told?
Right. Right. So I commend the president. What he has just said is presidential and it is backed up by law. And I give you the law. Aviation, Army is under the exclusive list. In Section 251, you will see it. And they are within the purview of the federal government. The president's declaration of no-fly zone is an executive order consequent on Section 5 of the Constitution that vests executive powers of the Federation to the president. And he made clear in that order for security reasons. The governor of Zamfara is trying to argue that there is no airport, and that is to suggest that in the first place there has not been flying. That, with greatest respect, is false, because you don't need an airport to fly the drones. You don't need an airport to fly choppers. And it is on record that terrorists in Nigeria, beginning from the northeast, have found solace in the use of advanced technology such as the drones and in some cases even chopper, to perform operation. I will even proceed to advise the president to also bound the use of motorcycle throughout the border towns of the Federation, because the bandits and terrorists use motorcycle to get maneuverability and have edge over the military in those areas. I will proceed to also advise the president, consequent on the powers that he has under Section 5, to make a declaration in a Council of State meeting which he will summon, that if any governor in the Federation of Nigeria negotiates with bandits, that state will be declared a state of emergency, and the governor will be removed on the approval of the National Assembly for the purposes of restoring law and order. There cannot be greater national security threat than bandits or terrorists in any part of the country to intimidate the executive officers of the federating units. Secondly, the issue of order shoot aside. That is also commendable, but it is not even like an extra work that the president has done, because even under Geneva Convention, the rules of engagement, any civilian that holds a lethal weapon is not a civilian, and therefore the use of deadly weapon is authorized. And the order of the president is very simple and straightforward. If you see anybody in the bush holding AK-47, shoot on sight. Supported by law, supported by Geneva Convention. So we do not expect that some group of persons under whatever name, America or international body, to come and teach us that. Let me even tell you something, Dr. Abati. About 4 days ago, thereabout, Christopher Wray, the new director of FBI, was having his congressional hearing. They confronted him with the question of domestic terrorism in the United States. They wanted him to make a pronunciation of profiling. They mentioned the Antifa. They also mentioned the Proud Boys. He declined from profiling, which is what I will tell you about the letter of Obasanjo that is no good. When you profile people, you are unable to deal with the situation. What Christopher Wray said was that we do not even investigate the ideology of Americans, because doing so would mean you're violating their right to hold thoughts different from the Federation. He said we investigate crime. And anybody who commits crime, under whatever guise of name, group, or ideology, FBI will come knocking at your door. That is presidential. And that's why the president, to me, must also get the Attorney General to approach the court and begin to get some elements that come under pseudo-names be proscribed, just like the way Boko Haram, by an order of court experte, that group was proscribed as a terrorist organization. FBI said all insurrection, all agitation that leads to the commission of a crime qualifies as domestic terrorism. So we must do that in Nigeria. Once the president declares that this is a domestic terrorism, then the laws governing the rules of engagement with terrorists will apply. You see, people want to intimidate this president. Now, I have disagreed with the president. I still disagree with him on some ways. His modus operandi, his inability to sack people when they go wrong and the rest. But on this matter of taking a first step, very bold step, even Obasanjo, who wrote the letter admonishing the president, during his time, he didn't have the carrot approach in his vocabulary, nomenclature, or dictionary. That is why today we have Federal Republic of Nigeria against Asari Dokubo, a locus classicus case. Federal Republic of Nigeria against Ganiu Adams, a locus classicus case. Federal Republic of Nigeria against Uwazurike, a locus classicus case. He was very brutal, and that is why this element could not seize the state. They could not intimidate the state. The president before now was being accused of being too soft and not being brutal. The president has just declared that take a bold step and cop this. And then the same people who were saying he was too soft are now beginning to say he should have been soft, that you should apply the carrot. So there is inconsistency sometimes in our policy agenda when we talk. This time, and with the way crime is finding itself and metamorphosing in the country, the only solution to it is brutal decision by the federal government. And that is not to take away other elements of the state from engaging with traditional rulers, engaging with this individual and the rest. While you do that, you must maintain a strategic advantage so that when you come to the negotiating table, you're coming from the position of strength.
Thank you for that, Dr. Bwala. Now, how do I begin this? So you just said about, you referred to former President Obasanjo's tenure when his instructions publicly televised were that suspected rioters at that time, if they refuse to, be arrested, if they resist arrest, they should be shot. That is completely different from what President Buhari is saying now. If you're bearing AK-47s, because we all know if you're bearing an AK-47, you're not exactly organizing a picnic, are you? It can be inferred that you are planning to kill people, you're planning to use it. So I do find that hypocrisy quite glaring. However, there are some merits to his letter. Several merits, including the emphasis on dialogue. Can we discuss that? Because you mentioned that earlier, that people are just not dialoguing, and that's one missing link here. And also, even though he completely ignored the carrots in his tenure, as you rightly said, it's still a good point to raise it now, hypocrisy notwithstanding. What form should those carrots take?
Right. So the carrot stick approach at the moment is first, identify the criminal element by their objectives. It is their objective that will determine whether they qualify for dialogue. Now, the army the other time made a very big mistake by initiating a program they call rehabilitation of the Boko Haram element, where they brought them up, gave them good health, gave them education, thinking about taking them to school, over and above people who have suffered death, destruction, and displacement of their rightful place from history. Now, that approach is wrong because the objective of Boko Haram is clear to the blind, deaf, and dumb, that they do not recognize the Constitution of Nigeria. They do not recognize the constituted authority. They want to dethrone the government and establish an Islamic state. How do you dialogue with this group? So there is no basis for dialogue. What you do is you fight terrorism. But there are other elements in the country who are raising agitation. I'll give you an example. The IPOB, until recently when they started picking up arms, they were not violent. What they are saying is that they want a cessation. Why? Because there is no development of government. The Igbo people are not carried along. They raise a number of issues. These individuals, you can identify and dialogue with them first by letting them know you have had all the opportunity, your representative have not been able to represent you properly.
Well, Daniel, on that note, we'd like to thank you very much for joining us on the morning show. Always a delight to have you on the show.